at second reading.
Thank you for your point raised. As I said, the committee would have to move for an adjournment. It would then be voted on, but these are significant points of concern and alteration for the bill, but that is for the committee to decide. Sean Woodcock.
Thank you, Chair. My point of concern is very similar to the one just raised, really, about the fact that at second reading, a key plank of this bill proposed was about the role of the High Court judges. Now, we're aware of an amendment coming via the move of the bill to remove that completely and change it with something else. But just that a lot of the evidence that we've seen, including the new stuff that has been raised by my colleague here, is in line on the expectation of that High Court judge and the role of the High Court judge. It's not on this new amendment. So I would suggest that we are missing vital perspectives on the way that this newly proposed amendment and the bill going forward would work in light of that. So that would be my registered concern.
Well, it's important that everybody has got their point on the record and that they have said and raised their concerns. One final point of order, I think it was Kit Malthouse.
I'm grateful. Just on a couple of points. I mean, first of all, it's worth saying that the amendments proposed by the bill sponsor are in response to evidence that has been heard by this committee, oral and indeed written, and certainly the bill committees that I've been on have had repeated information coming in as the bill has evolved. That's a natural process. But it's worth also pointing out to members that the bill committee is not the end of the process, and written evidence that will arrive throughout the process will be pertinent for report stage. When the whole House will have that information available, and members of the committee can then lead the debate and reflect on information or written evidence that has emerged even after committee stage, once the completed bill from this process is seen. So it's perfectly possible for this to evolve as we get to report stage and third reading in the light of evidence that arrives. And that's the normal process through which all legislation goes.
Kim Leadbeater.
Thank you, Chair. And just on that point, and I take on board people's comments, and there's no two ways about it, this is a considerable amount of work for members of the Bill Committee to undertake. But as has been alluded to, there are a wide range of amendments being proposed. And that is the job of the committee, is to take evidence, look at those amendments, discuss them, debate them, and then vote accordingly. And that is the process that we're all here to undertake.
We start with Amendment 178 to Clause 1, in the name of Kim Leadbeater, with which it will be convenient to consider Amendments 179, 180, 182 and 193. I call Kim Leadbeater.
Thank you, Chair. And it's a great pleasure to serve under you for this very important stage in the consideration and detailed scrutiny of this bill. We're discussing assisted dying for terminally ill adults who have a clear, settled, informed wish to end their own life and who have not been subjected to coercion or pressure from anybody else to do so. These are very serious matters and deserve serious consideration, which is why I was determined that this bill should have an unprecedented level of scrutiny. We've heard from a range of over 50 witnesses with differing views on the bill and have received written evidence from many, many more. I'm grateful to everyone who has contributed in such a thoughtful and constructive way. It's been widely remarked, and I wholeheartedly agree with this, that the second reading debate on November the 29th last year, when the House approved the principle of this bill by a majority of 55, showed Parliament at its best. I hope and believe that this committee, as it goes through the bill line by line, will do so in the same considered, respectful and measured manner. I will.
I'm very grateful, and I completely endorse that last point made by the Honourable Lady. Just remember in the second reading debate how many members, including I think herself, made reference to the judicial stage of the process, specifically the High Court judge. There were over 60 colleagues who have stated on the record that they voted for this bill at second reading because of that safeguard. Does she acknowledge that point?
I do acknowledge that point, and absolutely, as I've acknowledged, the role of the judiciary, the role of High Court judge is really important in this process, and that role will remain with the proposed amendment that I've put forward. But it will also do is take account of the very, very clear evidence we received during the oral evidence sessions.
Within the amendments as we go through this.
Thank you, Chair. And I hope and I believe that this committee will take that very same considered, respectful approach. I've been asked by the House to look at where the bill can be improved and amended so that Parliament can be presented with a piece of legislation that is robust and workable in order to meet the objectives it is designed to achieve. Most, if not all, of the amendments submitted in my name have been drafted with the help of Parliamentary Counsel and officials in both the Department for Health and Social Care and the Ministry of Justice. The Government is committed, as we know, to making this bill workable and operable whilst maintaining a position of neutrality. I'm grateful for the tremendous hard work that has gone into this to make a well-drafted bill even better, and I know the ministers on the committee, while remaining neutral, will be here to explain where necessary why some drafting amendments were needed to meet their duty to the statute book. There is an old adage that too many cooks spoil the broth, which may not exactly be Parliament language, Chair, but it's something we will have to bear in mind as we go along. Over 300 amendments have been proposed, most of them with the intention of improving and strengthening the bill, and I want to thank all MPs, whether members of this committee or not, for the time and effort they have put into this. We have a responsibility to maintain the integrity and adherence of the bill as a whole, so it's evident that we will not be able to accept all amendments. Indeed, we may find ourselves rejecting amendments that sound entirely reasonable in themselves and which undoubtedly come from a good place, but which are perhaps better addressed elsewhere in the bill. Others might have unintended consequences or create a degree of ambiguity or uncertainty that could undermine the legal authority of the legislation. That's very good for the pockets of lawyers, but it doesn't make for good law.
Kim Leadbeater, can I remind you that we are, talking to the amendments, and whilst a brief introduction is acceptable, we are talking to the
Absolutely, Chair, and I thank you for allowing me to make some introductory comments. With reference to amendments 178, 179, 180, 182 and 193 in my name, these amendments are simply to clarify that only persons in England and Wales may be provided with assistance in accordance with the Act, and only medical practitioners in England and Wales can carry out the required at each stage of the process. Hopefully a nice straightforward one to get us started, Chair.
Amendment 178 to Clause 1 is the amendment paper. The question is that that amendment be made. Oh, Stephen Kinnock.
Thank you very much, Chair. And I'd like to thank my honourable friend, the member for Spen Valley, for those introductory comments. The Government will continue to remain neutral on this bill and does not hold a position on assisted dying. I want to make it clear that I, along with my honourable friend, the member for Finchley and Golders Green, are speaking during committee not as members of Parliament, but as Government ministers responsible for ensuring that the bill, if passed, is effective, legally robust and workable. To that end, we've been working closely with the member for Spen Valley, and where changes have been mutually agreed upon by herself and the Government, we will offer a technical, factual explanation for these amendments. Therefore, I will not be offering up a Government view on the merits of any proposed changes put forward by other members, but I will be making brief remarks on an amendment's legal and practical impact to assist members in undertaking line-by-line scrutiny. The series of amendments that we are now debating has been tabled by the member for Spen Valley in consultation with the Government. I will give way.
Rebecca Hall.
Can I just ask how it interacts with voting on the basis of what you've just said? You've just set out clearly your involvement in this committee. So how does that impact any votes that you will take part in during this committee?
I thank her for that intervention. So I am on this committee as a Member of Parliament, and I vote as a Member of Parliament. When I speak on this committee, I speak as a Government Minister in order to provide factual and technical explanations. So, and as this bill is a matter of conscience, I'll be voting with my conscience on all of the amendments as they come forward. So I will... they relate to... these amendments have been tabled by the member for Spen Valley in consultation with the Government. They relate to the location of the person seeking assistance under the bill and are designed to ensure that the service can only be accessed by an individual present in England and Wales, with a view to preventing medical tourism. I will take the amendments in turn. Amendments 178 and 193 ensure that only a terminally ill person in England or Wales may be provided with assistance in accordance with the bill. Further to this, a requirement is placed on a coordinating doctor to ascertain whether, in their opinion, the person who made the first declaration is in England and Wales as part of their first assessment. Amendment 179 limits the assistance that may be provided in accordance with the bill to assistance in England or Wales only. Amendment 180 requires the steps taken under clauses 5, 7, 8 and 13, which relate to both declarations and both doctors' assessments to be taken by persons in England or Wales. Amendment 182 limits the provision of clause 4, subsection 3, where a person indicates to a registered medical practitioner their wish to seek assistance to end their own life, to cases where a person is physically present in England or Wales. This would prevent people who are outside England and Wales from accessing assistance in accordance with the Act, for example by online consultations from abroad. As I said earlier, Madam Chair, the Government will continue to remain neutral on the substantive policy questions relevant to how the law in this area could be changed. That is, as I have made clear, a matter for this committee and Parliament as a whole. However, I hope that these observations are helpful to members of the committee in considering the bill and the amendments put forward by the member for Spen Valley. Thank you.
Kim Leadbeater.
I beg to move.
Amendment 178 to clause 1. As on the amendment paper, the question is that the amendment be made. As members of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 34 to clause 1 in the name of Sarah Olney, with which will be convenient to consider amendments 36, 37, 38, 202, 39 to 44, name clause 1 and 45, new clause 1 and 45 to 47. I call Sarah Olney.
Thank you, Madam Speaker. Madam Chairman, I beg your pardon. Pleasure to serve under your chairmanship, and thank the member for Spen Valley for her opening remarks also. I'm grateful to be called so early in this to be able to talk, because this, I believe, is one of the really important issues before us as a committee considering this particular piece of legislation, and it surrounds whether or not somebody has the capacity to make the decision to end their own life, as it states in clause 1A. And I believe that the word capacity in this context is potentially difficult to define. I note that in clause 3, the reference referred to the Mental Capacity Act 2005, but I don't believe that for the purpose on this during the oral evidence, and I just wanted to reflect upon that. So I think there are 4 separate concerns about using the Mental Capacity Act to judge capacity. The Royal College of Psychiatrists, in their written evidence, their original written evidence, which we've all had sight of since early January, under the bill is introduced a person with a co-occurring mental disorder that is impacting their wish to end their own life would not necessarily be deemed ineligible. Only those whose mental disorder was deemed to impair their capacity to make a decision to end their own life would be excluded. So what that means is that you could have a terminal illness. You could also separately have a mental illness such as depression, and that would have an impact on your ability to make a decision as to whether that terminal illness was sufficient for you to ask for assistance with dying. So under the Mental Capacity Act, someone must be completely unable to understand the information relevant to the decision, retain that information, use or weigh that information as part of the process of making the decision, or to communicate that decision. And if they're only partially able to do so, they will still be considered to have capacity under the Mental Capacity Act. So it's not a safeguard to protect a terminally ill person who happens to be suicidal due to depression. And this isn't just a hypothetical issue. In a 2015 Court of Protection case, a woman with a personality disorder refused life-saving dialysis treatment. And the doctors felt that her personality disorder affected her decision, but the court held that she nonetheless had the capacity to make that decision, even though it would result in her death. Now, under this bill, a patient in the same position could opt for assisted dying, and the Mental Capacity Act would not protect them. And I'm not sure that this is acceptable to members of this House when they're considering this bill. So my amendment would replace the notion of capacity with a test of ability. And it's defined based on the functional test in Section 3 of the Mental Capacity Act, but it requires a person is fully able to understand, fully able to use and weigh the relevant information. And the addition of fully means that in the case of impaired ability, the person would not be considered to pass the test. Now, this means that a terminally ill patient with a co-occurring mental health condition which affects their judgment would not be eligible for assisted dying. Now, the member for Spen Valley said during our oral evidence session the intended beneficiaries of the law would not describe themselves as suicidal, but as drafted, the bill offers little protection to a terminally ill person who happens to be suicidal, and in my view it should protect them. And I strongly suspect that's something which the vast majority of colleagues who supported the bill at second reading would think is already in the bill. So the Mental Capacity Act also includes the presumption of capacity, and that is really, really important. A person must be assumed to have capacity unless it's established that they lack capacity. So you need to prove that somebody lacks capacity.
Will the Honourable Member be
Happy.
So,
Daniel Francis.
thank you, Chair. So the Mental Capacity Act is written to enable people to carry out day scenarios, buy a coffee, carry out their banking, etc., so that they're not being challenged at every transaction they're carrying out in life. It's therefore deemed a very low bar and deemed to be top capacity. Does the member believe it was written for this kind of scenario?
Sarah.
I thank the member for his intervention, and it's an absolutely relevant point, because the Mental Capacity Act, as drafted, did not anticipate that it would ever be used for this kind of scenario, and therefore it's really incumbent upon us to weigh very, very carefully whether the Mental Capacity Act is the right the right way of assessing people's ability to make this decision. And as I was saying, it includes the presumption of capacity, and for a decision to end one's life, an assumption of capacity to make that decision is a low bar, and we heard lots of evidence.
Danny Kruger.
I'm just interested in that point that the Mental Capacity Act haven't been written with this law in mind. That is absolutely true in terms of the minds of its framers and Parliament that passed it at the time. It is worth noting, however, and if you look into the accounts and the records of the Voluntary Euthanasia Society, who became guilty and dying a few years later, actually they were at the time lobbying covertly or behind the scenes for the Mental Capacity Act to be framed in exactly this way, because they were very conscious that when the time came to pass the law for assisted suicide, it would be very helpful to have a Capacity Act on statute that had this very low bar. So they were delighted when the Act was passed in the way it was, and they boasted at the time of the influence they'd had on the Act.
Sarah.
That's a very interesting intervention. I cannot comment on that because I have no knowledge of how the Mental Capacity Act was drafted, or indeed perhaps the evidence that was taken.
Simon.
I do believe that the Mental Capacity Act does enable people to stopping treatment, for example, in terms of cancer. So I would absolutely dispute your interpretation of it.
Sarah Olney.
Thank you for that intervention. You put your finger on the exact point. It is used for people to make a decision about whether or not they want to continue treatment. It has not been used before in such a capacity as in this particular way, and it wasn't intended to be used for this particular purpose. I can understand that you're making that if you're trying to say that to stop a particular treatment is akin to making a decision to take a proactive decision to end your life, but I would argue that it isn't, and that is why the Mental Capacity Act is not suitable for this purpose. It was interesting to reflect that we received around this particular issue. Chris Whitty, Professor Sir Chris Whitty, the Chief Medical Officer, stated in his oral evidence, issues around mental capacity are dealt with every day. Every nurse above a certain level of seniority should be able to do that normally. It may require some slight adjustment, and he acknowledged that the more serious the decision, the greater the level of capacity that someone needs to have. So, as in, just to take the Honourable Gentleman's point. But the Royal College of Psychiatrists was saying that an assessment of a person's mental capacity to decide to end their own life is an entirely different and more complex determination requiring a higher level of understanding. Happy to give
Sean Woodcock.
During the oral evidence, we had 3 sets of psychiatrists who all cast doubt on the suitability of the Mental Capacity Act for decisions such as assisted dying. Is your amendment an attempt to sort of alleviate those doubts and put that right in the bill?
Sarah.
Thank you for that intervention. Yes, that's exactly what I'm aiming to do here. And the Honourable Member makes an excellent point. There is a wide variety of view on this. But in actual fact, much as I don't wish to question Professor Sir Chris Whitty, and I acknowledge his seniority as the Chief Medical Officer, he was very much the outlier in this. Everybody else who gave evidence on the sufficiency of the Mental Capacity Act to determine someone's capability to make this decision for themselves, cast doubt that the Mental Capacity Act was the right way of doing it.
Kim Leadbeater.
I think that's probably not quite accurate. I think we did have other witnesses, and I will speak about them when I speak to these amendments, who absolutely said that they have confidence in the Mental Capacity Act.
Sarah Olney.
I thank the Honourable Lady for that intervention. I look forward to her further comments on this. But as I say, certainly the psychiatrists were very clear that they did believe that this was a sufficient safeguard, and that's something that I think we should acknowledge. And indeed, Alex Rutkin, KC, I was unable to put my question to him during the oral evidence session, and he very kindly agreed to give further evidence in writing further to a letter that I sent to him later that day, and that exchange of letters has been published as written evidence. It was his position that in actual fact Professor Sir Chris Whitty misinterpreted the Mental Capacity Act when he gave evidence. There is no such requirement in the Mental Capacity Act to say that the more serious decision, the greater the level of capacity that someone needs to have. Mr Rutkin's view is that that was the common law prior to the Mental Capacity Act coming into force, whereas in actual fact the Mental Capacity Act does not require that the more serious the decision, the more capacity they need to be judged to have. Happy.
I'm very sympathetic.
Jake Richards.
I'm very sympathetic to the problem that you've identified in terms of people who have a terminal illness but potentially have other mental health conditions. But instead of rewriting the Mental Capacity Act for this new context, would it not be better to secure safeguards through Clause 9? Further assessments are going to be mandated, actually, when the amendment from the member from St Albans is put forward, for those where there is a doubt as to capacity, adding a further safeguard rather than rewriting very established Mental Capacity Act legislation and case law.
Sarah.
I thank the member for his intervention. I have no intention of rewriting the Mental Capacity Act. That should stand exactly as it is and be used for the purpose for which it is intended. That is not the intention of my amendment here. Or my amendment here merely proposes that we should be seeing people's ability to make the decision and not just their capacity. And I believe that many different providers of evidence demonstrated that merely testing somebody's capacity to make a decision is not sufficient in this case. Happy to give
Dr. Simon.
We also heard from the evidence that if we make this more complicated and introduce more terms into the bill, then it will be less safeguarding for patients. And that's, I think, why we're all here. We're trying to make this bill safe for patients who are seeking assisted dying. I think changing it from the Mental Capacity Act will make it less safe.
Sarah.
I thank the Honourable Gentleman for his intervention. I heard particularly Professor Sir Chris Whitty say that he believed that a more straightforward bill that didn't have too many bureaucratic hurdles for people to overcome would be preferable, and that was why he was keen for the Mental Capacity Act to be retained. However, it is precisely because I don't think it is safe for people to be judged merely on the basis of their capacity, whether assisted dying is an appropriate decision for them, that I am proposing this amendment. So it is by no means my intention to increase bureaucracy around. I am merely proposing that the Mental Capacity Act is not sufficient in this case.
Nasha.
Thank you, Chair. 3 psychiatrists gave evidence to the committee in person: Professor Alan House, Dr Annabel Price of the Royal College of Psychiatrists, and Professor Gareth Owen. All of them expressed doubts about the use of Mental Capacity Act to assess whether a person was in a fit state or mind to undertake assisted dying. Does my honourable friend agree that we should place a very great weight on the opinion of psychiatrists when assessing whether the Mental Health Capacity Act should be used to assess applicants of assisted dying, given that it's a horse before the cart scenario, because it wasn't made for this. We weren't talking about the ability to choose to die at the time the Mental Capacity was passed, the Act was passed.
Sarah Olney.
I thank the Honourable Lady for her intervention, and I agree exactly with the point that she's making. The Mental Capacity Act was not designed for this purpose, and it is absolutely essential that we scrutinise very, very carefully whether or not the Mental Capacity Act should be used in this way.
Rebecca Paul. And can I remind members, interventions are just interventions. There will be speeches coming.
Thank you. I welcome the honourable member's attempt to improve the safeguarding of this bill. I totally agree that it is currently not at the right level. I think just to put in perspective, would the honourable member agree with me that at the moment under the Mental Capacity Act, it assumes a person has capacity in the first instance, evidence to the contrary. Whether a person lacks capacity must be decided on the balance of probabilities, and unwise decision-making does not indicate a lack of capacity, and supported decision-making is considered to be acceptable. I think we all need to be clear in this room that that is what the Mental Capacity Act currently says.
Sarah Olney.
I thank the member for her intervention, and she's absolutely right. I believe that would be one of the other weaknesses of the Mental Capacity Act if it were to be used in this context, is that if you're judged to have capacity, then you are free to make an unwise decision, and yet there is nothing in the bill as currently drafted to provide that safeguard against people who might have capacity and be making an unwise decision, but they're making that unwise decision because their thinking has been obscured by perhaps a mental illness or depression or something else.
Jake Richards.
A few questions for the honourable member. Who do you propose decides whether a decision by someone who has capacity is wise or unwise? Would the honourable member also propose changing the law around patients refusing life-saving treatment? Should that be handled under the Mental Capacity Act, as at the moment?
Sarah Olney.
I'm grateful to the honourable member for his intervention, but just to say again, I am not proposing to change any legislation other than the draft legislation we have before us. All the other legislation to which you refer should remain precisely as it is and for the purpose for which it was intended. And you say who's to say whether they're making a wise or an unwise decision. That is the job of the people who are instructed to provide assessments under the Mental Capacity Act. But you know, as I said in my response to the Honourable Lady earlier on, it's very clear that if you have assessed somebody as having capacity, then you are not free, you are not then able to, to take any further interference in their decision-making process, even if you have distinct concerns that that person may be making a decision to end their life, not because purely because of their terminal illness, but because they're suffering from depression. There is no other mechanism within the bill as drafted to enable that further safeguard.
Dr. Simon Over.
I use the Mental Capacity Act almost every week in my work, and as Chris Whitty said, the majority of cases it's very clear whether someone has capacity or doesn't have capacity. It's a sort of very clear and not disputable. There are some narrow proportion of people where it's more difficult to decide, and I think this bill takes a portion of that by using a panel to decide on those difficult cases of capacity, but most of them are very straightforward, I would insist.
Sarah.
I'd have to ask the honourable gentleman to clarify. When he says uses a panel, are you referring to this new amendment proposed that I haven't seen yet and can't comment on and have no idea if it's going to be adopted?
Can I come back,
Dr.
Chair?
Simon Over.
What I would say is that we're building in, we need to build in a way of, if we're not sure about capacity, we must refer to psychiatry to make a more detailed assessment of that from a specialist organisation. However, most people do not fit into that category. Most people clearly haven't got capacity or have got capacity, so it's a very narrow cohort. Thank you.
Sarah Olney.
I'm grateful to the gentleman for his intervention, and if I may say, Madam Chair, that it precisely illustrates what other members were raising as points of order
Maria Aurora.
The ayes to the right, 330. The noes to the left, 275.
More than 2 months on from the historic moment when MPs voted bill on assisted dying, today scrutiny begins. MPs are due to comb through the bill line by line, debating changes and amendments. But now, Kim Leadbeater, the MP behind the bill, has called for a change. Speaking to Sky News' Sophie Ridge, she suggested replacing the need for High Court judge approval with an expert panel.
What we need is a really robust third layer of safeguarding. But I have to be honest, I'm quite open-minded as to what that might look like.
So it doesn't have to be a High Court judge?
I think there's a role for other experts to play. We took evidence from the association.
There wasn't more opportunity before this legislation was drafted to have had these discussions between experts, between advisors, between people who really know what the Mental Capacity Act means and whether it's sufficient for this purpose. The best we can do now is reflect upon the evidence we've received. But in many ways, that's what I'm hoping to address with my amendment, that we can redefine capacity as ability and then transfer the responsibility for defining how ability should be assessed under this Act to the Secretary of State for further, analysis, further consultation, and then for that to be laid out properly. I'd like to make a bit of progress. What we want to take into account when we are assessing people's ability to make this decision is their ability to understand, to retain, to use and weigh information and to communicate the decision. That will still be at the heart of an assessment of whether an individual is making this decision for the right reasons. But there's a whole range of things that might affect people's ability to take the decision. There are mental disorders, as I've mentioned many times, such as depression, which is more common in people who are nearing the end of their life. Delirium, that needs to be assessed, and that obviously is common in people with advanced illnesses. The complexity for people who've got a physical terminal illness alongside a mental disorder. I think particularly of people suffering perhaps from an eating disorder, because that's obviously primarily a mental health condition, but clearly it has physical health implications. And if the mental health condition is not treated or is resistant to treatment, then obviously the physical manifestation of the eating disorder can very quickly then become a terminal illness. And that is a really, really important point that we need to reflect upon. The feelings of hopelessness that may come alongside a diagnosis of terminal illness may affect a person's ability to weigh information. Anxiety can amplify their fears of future suffering, and types and doses of medication can impact capacity. And all sorts of people can suffer vulnerabilities from external factors such as the lack of realistic alternatives such as palliative care services, overt or implicit coercion, personal losses including bereavement, poor housing, financial hardship, loneliness, social isolation. So understanding and responding to those vulnerabilities is at the centre of suicide prevention, but are absent within this bill. So we have to remember this bill would apply to people who are said to be within months of death, but may not be, those who may die within months but otherwise have a very good quality of life, and people whose trajectories to death vary greatly. Professor Alan House, in his written evidence, stated, "Careful inquiry is justified because a statement about wanting to end one's life cannot be simply taken as a result of a straightforward, rational decision to choose one type of end-of-life care over others. Simply checking mental capacity and asking about coercion is not adequate."
Will the honourable member give way?
John Gordon.
Thank you very much to the honourable member for giving way. I understand the concerns that she's making about assessing mental capacity. Does she acknowledge that throughout this process, mental capacity will be assessed not once but multiple times? And what would she say to that?
Sarah?
I would say to that what I've been saying throughout, that a test of mental capacity is not sufficient for this bill. For example, the Royal College of Psychiatrists stated that the Mental Capacity Act is not sufficient for the purposes of this bill. Extensive consideration needs to be given to what an assessment of mental capacity should consist of for decisions relating to assisted dying or assisted suicide. And indeed, whether a determination through such an assessment can be reliably arrived at in this novel context. And I believe by novel context what they mean there is that no legislation of this type has been framed before, and we don't have any precedent to guide us in terms of what an appropriate consideration of capacity might be. Happy to give way.
I do apologise to the Honourable Lady for keeping interrupting her, but there are some important points I'd like to put across. And at present, in our medical system, the Mental Capacity Act is used to test capacity in cases of withdrawing life support. So would not you agree that that is on the same level as assisted dying?
Sarah?
I have a suspicion in his many interventions, he may have made that point already, and what I would say is that withdrawing treatment is not the same as making an informed wish to have your death assisted. And I think that is why we need to be very, very careful about considering whether the Mental Capacity Act is appropriate for that kind of decision. So just in conclusion, the Mental Capacity Act is being used in a way that it was not designed for. Using this definition of capacity is to accept the premise that this is just like any other treatment option and not qualitatively different, and fails to recognise the complexity and gravity of the decision. And the bill also fails to consider that there may be a risk of assessor bias, that sometimes it may well be that a doctor making this assessment may well have their own views about the suitability of assisted dying as a route or as an option for that particular patient. They may be in favour of it, but they may also be against it. And if that were to sway them to making perhaps an assessment against capacity, that could have lots and lots of serious implications for the patient. So I am proposing this amendment because I think the best way forward at this stage, given the variety of evidence that we've had and the real difficulty for us in this room of making an appropriate determination of the extent to which the Mental Capacity Act, its use may be modified for this purpose or for coming up with something entirely new. I think the best way forward is to give the power to the government, to the Secretary of State, to define the term ability in relation to this legislation at a later date. And that is why I am proposing this amendment. Thank you, Madam Chair.
Amendment 34 to Clause 1. As on the amendment paper, the question is that the amendment be made. Dr Marie Tidball.
Thank you. With respect to the Honourable Member for Richmond Park, I do not support the amendment she has moved this morning, replacing the Mental Capacity Act references with the concept of ability in the bill for a number of reasons. Firstly, medical practitioners already know, regularly use and well understand the Mental Capacity Act 2005. As a result, as Professor Chris Whitty said in evidence, where practitioners conduct such an assessment of an individual separately, they are usually in agreement in their decisions about the outcome in relation to that individual. And also, as mentioned by the Honourable Member for Stroud in his intervention. Secondly, the term ability, unlike mental capacity, is not an existing concept in law that we can draw upon in the context of a complex medical decision-making about consent to medical treatment. Therefore, I do not accept that it is a low bar. Now, I will make some progress. Thus, replacing an established concept of mental capacity with ability creates more problems than it seeks to solve and is not underpinned by a clear statutory basis. Further, the language she uses in her amendment only echoes the wording of the second leg of the two-stage test in the MCA, in its language of fully understanding, using and weighing the relevant information. It does not, however, have the scaffolding and the clarity of the 5 principles set out in the Mental Capacity Act, and is a pale imitation of that second stage test of capacity, which is already in Section 3 of the MCA. Thirdly, the use and application of the Mental Capacity Act has been applied and litigated upon in our court system over the last 20 years, further nuancing its application in complex medical decision-making and explicating, for example, the 5 principles in the MCA and the subsequent 2-stage test for capacity. And contrary to what colleagues on the opposite bench have said already, it is used in cases where treatment is withdrawn. And it's important to understand that in those circumstances, such withdrawal is not seen as an omission, it is seen as a deliberate act, therefore is analogous to the usage in the bill as proposed. Fourthly, I have very deep concerns that the use of the term ability and the concept expounded in New Clause 1 imports an ableist approach, which I do not welcome as someone who has worked in disability rights and policy for over a decade and a half. Turning to my first argument about the familiarity and usage of the Mental Capacity Act by medical practitioners. Clinicians and the wider social care profession for 2 decades, and this is also something that many family members will be familiar with and used to using as part of the wider care of people with learning disabilities, autism and mental health problems. So the boundaries of those who are familiar with this concept goes well beyond the walls of only medical practitioners. During the oral evidence sessions, Professor Chris Whitty, Chief Medical Officer, stated, and I quote, that the Mental Capacity Act is used up and down the country by doctors and nurses every day. They know it and they understand it. Although it is a large piece of legislation, it is one that people have worked through in practice multiple times. If you ask 6 or 7 doctors, does this person have capacity? In almost all cases, you will get 6 or 7 identical answers because people are used to using it. To unleash the tiger of an unknown and untested concept of ability into a bill which would benefit better from the well-understood, measured and principled approach of the Mental Capacity Act 2005 does not best serve the patients that I know the Honourable Lady is seeking so carefully to protect. Therefore, it is worth laying out the paradigm which underpins the MCA and the principles it legislates for, and why, therefore, it is so important to retain this at the heart of the bill. The presumption of capacity in the Mental Capacity Act exists because it is considered a fundamental principle of respecting individual autonomy, meaning that every adult is assumed to have the ability to make their own decisions unless there is clear evidence proving otherwise. This protects against unnecessary interference in people's lives and ensures that they are treated with dignity and respect, even if they may have a disability or medical condition that could potentially impact their decision-making abilities. I also, at that point, want to reflect on the robust language in Clause 2, subsection 3, which states, for the avoidance of doubt, the person is not to be considered to be terminally ill by reason only of the person having one or both of the following: a mental disorder within the meaning of the Mental Health Act 1983, a disability within the meaning of Section 6 of the Equality Act 2010. That provision, along with the tightly drawn limit on the need for the person's terminal illness to be leaving them with only 6 months left to live, and then the third stage of that test, of it using the Mental Capacity Act to understand their decision-making, means that we have, across those 3 things, a very strong set of safeguards.
Will she give way?
I will give way to the Honourable Lady, who asked first of all.
Sarah Olney.
You moved on considerably from the point that I was going to make.
Great progress, and I appreciate her patience.
So I took it that you were not going to be taking interventions, and while I would have liked the opportunity to respond to some of the points you were making, I have kept my counsel. But since you have now given way, I did just want to, maybe as a point of order, you've mentioned that you thought my use of the word ability was ableist. And I just want to put on record, I had absolutely no intention of it being interpreted that way. I meant no offence, and I really hope that that would not have been considered in such a light, and if that had caused any offence, then my apologies. But I hope that the general meaning of the word ability is well understood in this context.
Well, I very
Dr.
much
Tidwell.
thank you. I very much am grateful for her making that statement, and that isn't the assumption. The term ableism is very much, and this is what I will say later on in my speech, is grounded in an idea that it takes a deficit model of disability. So it assumes that somebody doesn't have capability of doing something, i.e. important decision-making themselves, whereas in the Mental Capacity Act, it starts from the different perspective. It assumes that person and presumes that person will have the ability to do something until it's proven otherwise, which is why I feel that this concept of ability does not align well with what's needed in terms of understanding and providing autonomy to people making very, very difficult decisions at the end of their lives.
You also give way?
I will at this stage.
Danny Kruger.
I'm very grateful, and she very accurately quoted clause 2, subsection 3, about a person not being considered to be terminally ill by reason only of having a mental disorder or disability. That word only is very important, does she acknowledge, and does she recognise that that explicitly allows for somebody whose judgment might be impaired by a mental disorder still being eligible for an assisted death, because they would still be judged to have capacity under the terms of the Mental Capacity Act. So that term only is in fact not a safeguard, it's an access for an assisted death for somebody with an impaired judgment.
Dr. Maritin.
Thank you. I thank the honourable gentleman, and no, I do not agree, though I appreciate his intervention. As I said, I think taking together the parameters around the 6 months, along with clause 2, subsection 3, and the requirement to make a mental capacity test, acting together creates a cumulative safeguard within the bill. And importantly, this comes to my next part of my speech, there are already robust safeguards which underpin the MCA in its 2-stage test for capacity, which addresses exactly the issue he raises. So stage 1 is asking if there is a disturbance or impairment in the person's brain or mind. And stage 2 is the disturbance or impairment severe enough that the person can't make a specific decision. So that 2-stage test already deals with the issue that the honourable gentleman raises. And just as I believe it is right that the capacity under the Mental Capacity Act is imported in the relevant clauses under the bill before us today, crucially doing so, as I've suggested already, ensures we import this test too. Elements of the language in the Honourable Lady's new concept of ability appear to attempt to echo the 2nd stage of that Mental Capacity Act test as just described, which has 4 elements to it: understanding information about the decision to be made, retaining that information in their mind, using or weighing that information as part of the decision-making process, or communicating their decision by talking, using sign language, or any other means. And I think it's important to say that those core elements are built upon the scaffolding of the 5 principles of the MCA and work in a progressive way. I also want to just return to one point before I give way to the Honourable Lady, that colleagues opposite, Honourable members opposite, talked about the unwise decisions. Actually, the principles in the Mental Capacity Act work collectively and cumulatively together. So that is only one step, which is followed by the fact that decisions must be taken in the person's best interest. And there is well-worn, well-trodden understanding of how we ascertain that. And that's really important, that those things all work together. And there is, so I think that that issue is already addressed in the MCA, and if we do away with the MCA, we lose not only the scaffolding of the 5 principles, but the important safeguards in the 2-stage test. I think I promised my Honourable Lady
I thank the Honourable Member for giving way. Just to point to her, she made reference to this has already been done, but where is the evidence that this is actually happening, that the capacity, the stages that you talk about? So we've had evidence from the Royal College of Psychiatrists, we've had evidence from the Honourable Member refers to Professor Chris Whitty. Where is the evidence that this has actually been done well as it is?
Well, Dr. Maritin.
I don't have a list of case law in front of me. I'm sure it would be possible for that to be found for you, but this is something that is done regularly in a Mental Capacity Act, is used regularly in decisions about the withdrawal of life support treatment. So that is the case. She's welcome to search for the case law. I promised the Honourable Lady I would take
I'm grateful to the Honourable Lady for giving way. She talks about the 4 tests and the parts of the Mental Capacity Act. I mean, the point that I'm making is that there are elements of the Mental Capacity Act that we absolutely want to retain. It's using it in its entirety that is problematic in this context. So the 4 functional tests about whether you're capable of making a decision absolutely should be retained. And as she says, it's well tested, it works well, people understand in a court of law exactly how to apply it. It's some of the other elements of the Mental Capacity Act that are problematic, and that is why I am seeking to redraw capacity to ability, I accept that may be a problematic word, but I hope she will take on board my earlier comments about that, and that's what's important. So she's saying we shouldn't destroy, take out those bits of the Mental Capacity Act that are valuable and important, and I agree with her.
I'm pleased to hear her agreement, and as someone who has worked in this space for a very long time, I would say to her, if she does not want to have the impact in law of putting in place a concept which would be ableist, which would take a deficit model of disability, then we need those 5 principles which are embedded in the Act already, and then we need the very stringent 2-stage test, which then, with the 2nd stage, has the 4 elements that I've already set out. And it is only that we can be certain that we are approaching the paradigm of this very complex and important decision-making as one where we are understanding the autonomy and best interests of groups of people that we would all wish to best protect. Which leads me to my... I will make some progress, but thank you. The concept that the Honourable Lady sets out is the bare bones of what is needed in the complex decision-making required across various stages of the bill before us. Decision-making which the MCA has a wide and well-used toolkit to determine capacity, which leads to my 3rd point, that the Mental Capacity Act has been applied and litigated in our court system over the last 20 years. Professor Sir Chris Whitty, Chief Medical Officer, in his evidence said that the Mental Capacity Act has the advantage of being tested in the courts, that has gone as far as the Supreme Court, and the various ambiguities that were inevitably in the legislation have been clarified by senior members of the judiciary. Therefore, to practitioners like me, it feels like a piece of robust and practicable legislation. He continued, if there were no mention of the Mental Capacity Act, there would be an argument, which has been used for a long time, that the bill would have to define what was meant with a fair degree of clarity. I do not see sufficient clarity in the Honourable Lady's proposed concept as set out in this amendment. In a separate witness session, Yogi Amin, solicitor and partner at Irwin Mitchell, further augmented Sir Chris Whitty's argument. I wholly recommend and support the idea to defer to the Mental Capacity Act for capacity assessments. I have been working in this area for over 20 years, before and after the Mental Capacity Act came in. And I have done cases all the way up to the Supreme Court, as well as day-to-day different cases around the country. It is well understood how capacity assessments are done, and it is ingrained into the practice of practitioners generally and of legal practitioners in the courts. It is also, he continued, well settled and understood approach to the law, and producing a new concept would throw up a whole new conundrum where people would be questioning how to approach. It is not broken, it works well. And finally, just for further clarity, I will be voting against the amendment because of the ableist assumption in both the language and the approach of this concept. Ableist language is used, ableist language assumes disabled people are inferior to non-disabled people and perpetuates deficit discourses about such groups. And I believe this approach does not take the approach that we see in the paradigm of the Mental Capacity Act, which puts the choices and autonomy and control over those choices of disabled people at the heart of this legislation.
I'll go to Dr. Neil Shastri-Hurst.
Thank you very much, Chair. I'd like to thank the Honourable Lady for Richmond Park for tabling these amendments. I fundamentally don't agree with them, but I'm grateful because I think she brought them with good intentions. And I do understand the concerns that she's raised, and she makes an eloquent argument for the case. But as I say, I do fundamentally disagree with them. These amendments would, in my view, only serve to abandon what is already a well-established principles as codified within the Mental Capacity Act, and introduce a degree of willingness and legal uncertainty by introducing a new term that is as yet undefined, and that would make the operability of this piece of legislation so much harder. To move away from the Mental Capacity Act that has a heritage of some 20 years or so, which is already well established in the use of advanced directives around organ transplantation, around withdrawal of treatment, around the decisions of major operations, which can have life-changing or life-limiting consequences, is well established. And practitioners, I will give way.
I'm very grateful.
Danny Kruger.
I'm grateful. He says that the term ability is not yet defined. Well, it's set out quite clearly in New Clause 1, which the Honourable Lady has tabled. And it's very simple. It just simply says that a person is considered to have the ability to make a decision if they can fully understand, use and weigh the relevant information. So it uses the language of the Mental Capacity Act about understanding and weighing information. The key distinction is that it doesn't allow for impaired judgment. It requires somebody to have to fully understand the information that's in front of them. That is very straightforward. I don't think that would be difficult to apply. Does he recognise that the terms are actually pretty clearly laid out?
Dr. Neil Shastri-Hurst.
I'm grateful for my honourable friend for that intervention, and as always he makes incisive points and he makes them clearly and concisely. I'm not going to agree with him on that point. This is a short clause which is dealing with a hugely complicated issue, which is presently codified within the Mental Capacity Act, which runs to some 183 or so pages. So I don't think it's as simple as saying a new clause deals with that issue. Of course, there is the two-stage test as well, which determines both the functional ability to make that decision, but the issues around whether that decision is impaired in any way, shape or mean. So I think it would be an oversimplification to suggest that the amendment as drafted would deal with those issues in a satisfactory way that would not only provide confidence, most importantly, to those who are making a decision around an assisted death, but would also give confidence to medical practitioners who are part of that process and to the courts who will have to grapple with these issues which would inevitably arise from a new definition. And we'll give
Sean
way.
Woodcock.
Thank you very much. I'm grateful for him. Honourable Member giving way. The Royal College of Psychiatrists highlight that a person's capacity can change and that it's decision specific. And therefore they say that for that reason the Mental Capacity Act is not suitable for this bill. What is the Honourable Member's response to that?
Dr. Neil Shastri-Hurst.
Well, I'm grateful to the Honourable Member for his intervention. He's absolutely right. Capacity can change. It is an evolving piece. Your capacity at one point in time is not necessarily the same as your capacity at a future date or a previous date. But that's the whole purpose of the bill as it's drafted, that there are a series of mechanisms in place which are assessing capacity as you go through in order to ensure that this is a robust decision-making process. But I'd also mention that in the Mental Capacity Act as it's drafted, it allows the capability of individuals to make an advance directive. So where they have capacity at a point in time to make a decision for a future date, that infers capacity at that future date for that decision. So we acknowledge that within this piece of legislation from 2005. I will give way.
I'm very grateful to my honourable friend, and I have to confess myself a little bit confused by the evidence that the honourable gentleman refers to, because perhaps he could confirm it's perfectly possible for me to be diagnosed with a terminal disease and make an advance directive that may apply in 3 months' time, that in those circumstances I would decline treatment and wish to die at that point. And the Mental Capacity Act is used to assess me making that advance directive, having had my terminal diagnosis. So if it's good for that decision, I'm struggling to understand why it wouldn't be good for a similar decision to end my life in similar circumstances.
Dr. Neil Shastri-Hurst.
Well, as always, my honourable friend makes a very good point, because, of course, the Mental Capacity Act does allow for advance directives on a whole variety of choices, whether that's withdrawal of treatment, whether it's decisions around care or financial elements, whether it's decisions around having treatment as opposed to not having treatment. So, absolutely, it creates that ability, and it is deemed robust enough for those purposes. I therefore say it must follow from that it is robust enough for the purposes of the act the bill that has been put forward. I'm aware the honourable member wishes to.
It's very kind of the honourable gentleman to give way. I just wanted to probe a little bit more about this this capacity to make a future directive. Are you saying that, in the terms of the bill before us as it is drafted and its reference to the Mental Capacity Act, it would be possible for somebody to say, at some future point, I may not be eligible now, I may not even be suffering from a terminal illness now, but at some future point, because I have capacity today to make that decision, I should like to choose assisted dying. And for that decision to then be honoured at that future date without any further intervention or assessment.
Dr Neil Shastri-Hurst.
Well, the honourable member makes an interesting point, and one that I have considered and in fact tabled a new clause on addressing that particular issue, which is not to be dealt with in this particular grouping, but I will just touch on it if I may. There is an argument that if you've gone through the two-stage test of the bill as it's currently drafted and then lose capacity, if you have an advance directive in place, there is an argument that that advance directive should hold weight. And so therefore I have tabled an amendment dealing with that point, because what one will note from I think it's sections 26 to 28 of the Mental Capacity Act, is that, no, 27 to 29, I correct myself, deals with exclusions from advance directives. So issues around voting rights, for example, marriage rights, Mental Health Act implications. So there may be a mechanism, for example, of excluding an advance directive that deals with assisted death, either through the bill itself or through an amendment to the Mental Capacity Act. But I don't disagree, she raises an interesting point.
Danny Cruden.
I'm very grateful. Just to clarify then, is he acknowledging, and I think my honourable friend for North West Hampshire is making the same point, is he suggesting that it's inappropriate, which I think his amendment makes this clear, for an advance directive to authorise an assisted death, whereas the Mental Capacity Act authorises somebody to decline treatment at a future point? He's acknowledging there is a difference in these two principles, in these two cases, between the principle of declining treatment and the principle of requesting an assisted death. I don't imagine that the honourable gentleman, because of his amendment, actually does think that we should have advance directives that authorise an assisted death. If he acknowledges that, he recognises there is a distinction between declining treatment and requesting an assisted death.
Dr Neil Shastri-Hurst.
My honourable friend makes a valid point, and I do have concerns about public confidence in the bill if there isn't that additional safeguard, given that this is such a consequential decision. But of course, any advance directive would be predicated upon having those two stages first before losing capacity. But I just felt on this occasion it needed that additional tightening for confidence of the public to know that this is a robust process that has gone through. If I can make some way. So as I say, this is, the MCA as it stands is a tried and tested piece of legislation that is used by practitioners up and down the country. The Honourable Member for Stroud uses it every day in his practice. I have to say I possibly didn't, but I wasn't always consenting patients for surgery every day. But every time I did so, you did have those conversations, and there is a spectrum of where capacity lies. You know, if I am doing major abdominal surgery, for example, the level of capacity to make a decision on that is much greater than if I'm removing a small bump or lump on an arm, for example. So it is tried and tested by medical practitioners, but it's also, as the Honourable Member for Penistone and Stockbridge has said, been tested in the courts. It's been right up to the highest court in this land. It has been robustly tested, and it has been found to be a good piece of legislation. The risk that we face now is to replace it not only with a new legal concept, but an entirely different process for assessing the idea of capacity in this setting. And I say that whilst there may be good intentions to improve the system, that is only going to add, I say, to the folly of it and overcomplicate the issue. I can see my honourable friend.
Kim Leadbeater.
Sorry, it's taken me a while to find this in the bill, but just on the issue of the advance directive, which I think is a really interesting discussion, and I'm glad we're able to have it. Is he reassured that in clause 18 of the bill, subsection 4, it's very clear that actually on the day that assistance would be provided to a patient, the doctor has to once again assess capacity to make the decision to end their own life, and again has to check that it's a clear, settled and informed wish to end their own life. and indeed has to check everything again on the actual day, including capacity. So I believe that would negate the issue around advanced directive.
Dr Neil Shastri-Hurst.
Well, I'm grateful to the honourable member. She makes a reasonable point, and I agree with her on many issues. On this, I have some reservations, and the reason for doing so is because what Clause 18.4 says is the coordinating doctor must be satisfied at the time of the approved substance is provided that the person to whom it is provided has capacity, has a cleared, settled, informed wish to end their life. But of course, through the wording of section 26(1) of the Mental Capacity Act, that decision can be made at an earlier time and deemed to have currency once capacity has been lost for the enactment of that act at a future date. And therefore, I think there could be some minor tightening up of the wording there, or reassurances from government that may be able to alleviate that point. But I think it's an important point to air and raise. I'm going to give way to the honourable member.
Before we proceed any further, we are discussing capacity and ability. Nasha.
Thank you, Chair. I thank the honourable member for giving way. I'm just trying to understand the what you're communicating. So, if somebody has anorexia or diabetes or has kidney failure, and they then decide that they have the capacity in relation to the bill as it stands to make that decision, and then they decide because it meets the capacity for them to refuse treatment and they meet that criteria, does that mean to say they can then sign up to this option?
Dr Neil Shastri-Hurst.
The bill is very clear in determining that it is for those who have a progressive illness, disease or medical condition which cannot be reversed by treatment. So I think it excludes that category of individual, on my reading of the bill, who chooses not to engage with treatment that would, in ordinary circumstances, prevent the progression or deterioration of their condition. So I don't see it as analogous with the scenario that you put forward of somebody who could have a long life expectancy had they taken their treatment but chooses not to. I don't think that is captured within the bill under my interpretation. I will give way.
I thank the honourable gentleman. I'm really struggling with this because from the evidence that we've heard during witness statements, it's very, very clear that that is where if somebody has anorexia, for example, and they make that choice. So we've had the references plenty of times that the Mental Capacity Act here, in this context, in the context of this bill, has been used and is sufficiently used for people to withdraw treatment. Personally, I think that's a pretty false equivalence because when you're turning off somebody's life support machine, it's not the person who's making that decision, it's your loved ones who are making that decision. So it's not the actual person who's receiving that life-saving treatment, for example, on a life support machine. What I'm trying to understand is, according to what we've heard this morning, if you have the mental capacity, and we're using this act, the MCA, to withdraw treatment itself for a condition, that will then lead to a diagnosis of terminal illness. It could kill you. If you refuse to treat, if I refuse to take insulin and I was a diabetic, I have the mental capacity to say, actually, I'm not going to take this treatment, so can I make a decision? I'm just trying to understand his understanding.
Dr Neil Shastri-Hurst.
With the greatest respect to the honourable member, I think she's conflating two issues. You can stop treatment under the MCA, and that will lead, over a period of time, progressively to death, if it is with some conditions. For the example she gave of being a diabetic without insulin. But that wouldn't be a terminal illness within reference to this piece of proposed legislation. The legislation is very clear that it is about an inevitable progressive illness, disease or medical condition that cannot be reversed by treatment. Diabetes, through the treatment of insulin, is not a progressive condition that it becomes a terminal diagnosis. It is only terminal by virtue of somebody refusing treatment, which therefore would not be captured within the words of this bill. I will give way.
Rebecca Paul.
Thank you for giving way. I'd just like to understand why you think diabetes could ever be considered to be reversible. It can be treated and managed, but surely you can't turn back time.
She makes a valid point. You can see that I was an orthopaedic surgeon and not an endocrinologist. But it's not necessarily a progressive condition. It is a condition that can be managed and maintained. It does not fall within the category of the wording of this bill. We're not talking about a condition that is inevitably progressive, that there is no treatment option available to see, either pause, reverse, or prevent progression of that condition. We are talking about a group, relatively limited group of conditions, which will inevitably lead to death. The treatment, for want of a fairly blunt phrase, you've reached the end of the road in terms of your therapeutic treatment options. I will give way.
Sarah on.
And I'm conscious that the gentleman on the other side of the room was before me, but I just wanted to press him slightly on that, because when I asked Professor Sir Chris Whitty during the oral evidence if there was could ever be a defined list of conditions that he would define as terminal, he was very clear that there wasn't, there couldn't be, that there could be, you could be suffering from a range of conditions, and that, you know, many people who catch cancer, in fact most people who get cancer, develop cancer I should say, survive. So cancer is a terminal illness, but not for everybody. And so in actual fact, the question of what is and isn't a terminal illness is actually quite contested, and it's not clear cut. And as the Honourable Lady just said, it's quite possible that diabetes could be a terminal illness if you do refuse to have treatment for it. So I'm not entirely clear what he's saying, why he's saying that it's really clear in the legislation what is and isn't a terminal illness. As we heard in the oral evidence, it's not clear.
Can I just remind members there is actually a clause later on where we discuss terminal illnesses and extending the list for terminal illnesses. So if we can remain within scope, we continue the amendments that we're discussing this morning. Dr. Neil Shastri-Hurst.
I will keep it very brief to say that I will come back when we come to the terminal illness bit, and perhaps elucidate and improve and work on my responses in a way that's conducive. I'm aware the honourable member.
I'm very grateful. The honourable member has given away a number of times. I'm sure wants to make some progress. Just go back actually to the scope, Chair. I'm sure you'll be delighted to hear. Part of the rationale for making this change from capacity to ability was cited as depression in the event that someone becomes depressed after diagnosis, which I'm sure is a very real possibility given what we're talking about. In your experience, Dr. Shastri, when they come to make potentially life-changing decision-making about current treatment or whatever it might be, you consider them they may have a clinical diagnosis of depression. What is the situation currently with the Mental Capacity Act when it comes to that? Are they able, in your opinion, and capable of making those decisions? And are there any scenarios, for example, where you would say or offer or recuse them of certain treatment because of their depressed state? What I'm essentially getting at is clearly when it comes to depression, there are a huge number of scales and considerations to factor in. And under your opinion, does the Mental Capacity Act facilitate those kind of considerations when it comes to depression?
Dr. Neil Shastri-Hurst.
I'm grateful to the honourable member for his intervention. He's right. This is a huge spectrum of patients when you're dealing with these sort of complex issues. And to arbitrarily say anybody with depression is unable to make an informed decision on any issue would be a nonsense. It would be an absolute nonsense. There are those individuals who may have mild depression. I would suspect most people with a terminal diagnosis would have some sort of, whether formal diagnosis of depression or reactive disorder because of the circumstances that they find themselves in. That doesn't mean that as of themselves they're unable to make a rational, informed decision. You have to look, I will give way in a moment. You have to look at each patient in an individual basis. But this is a tried and tested piece of legislation that doctors use up and down the country every day. There are doctors over the road in St Thomas today who will be using it at this very moment. And they are adept at knowing and sensing when they need to escalate that. whether that's through getting a psychologist's opinion or a psychiatrist's opinion, because they have some concerns about the underlying issues. This is a robust piece of legislation that we should be using to enhance this bill, not seeking to put added complexity to it, which is only going to put us into a quagmire of uncertainty. I will give way.
Danny Crew.
He doesn't want uncertainty, so perhaps he could answer this question very directly. Would he be content to see somebody who is depressed and indeed suicidal successfully apply for an assisted death?
Dr. Neil Shastri-Hurst.
My honourable friend puts it in with his usual candour. And it's a straight question, I'll give him a straight answer. I think there is a difference between somebody who is depressed and somebody who is depressed and suicidal. I think I have no personal moral objections to somebody who has a terminal illness, who suffers from depression, who has capacity, as set out through the Mental Capacity Act and that two-stage test, if they ultimately wish to end their life because of their terminal diagnosis. If they are doing it because they are suicidal as a consequence of their depression, I think that is a different, distinct issue. We're talking about individuals who are wanting to end their life because of their terminal diagnosis, not because of their mental disorder. I will give way.
Jake Richards.
I'm very grateful. I keep making the point that Clause 9 adds a different element to this whole process and issue we're discussing, because what that says at the moment, it says that one of the two doctors may, when undertaking the assessment, if they have a doubt as to capacity, refer the person to a psychiatrist for assessment on capacity. Does that offer reassurances to my honourable friend in this regard, a further layer of safeguard in this area? Yes.
Dr. Neil Shastri-Hurst.
We're grateful to the honourable member for his intervention. Yeah, that is one of the additional safeguards that is within this bill. I mean, when you compare it to similar pieces of legislation across the world, this has more inbuilt safeguards in it than any that I can think of. And so I think he makes a valid point. There is that option available, of course, where you do have concerns about somebody's mental state, and you can effectively escalate it and seek further specialist opinion. I will make some way, if I may, because I think I've been indulging the chair's patience for far too long. I am cautious against introducing this new test. I think I've set the reasons out. I may not have persuaded everyone, but I've set my reasons out. I think we risk making it an overcomplicated system. We move away from what is a well-established mechanism through the Mental Capacity Act. We enter into tiger country of untried and untested systems which the courts have not considered, which will inevitably lead to challenge. When there is no need to do so. There is no need to do so because you've got the robust mechanisms that are all in place. And I think that merely leads to ambiguity and potential complications. And this is not me reaching this conclusion in isolation. And of course, there will always be voices on different sides of the debate, and we can frame the evidence we've heard to favour one set of arguments over the other. But I am significantly persuaded by the Chief Medical Officer, given his wide experience, not just as a clinician, but as a public policy maker, in his evidence to this committee on the 28th of January. And I particularly note what he said was he's not clear to me what problem people are trying to solve by doing this. And by that he means by moving away from the Mental Capacity Act. He said, given that the Mental Capacity Act clearly makes the point that the more severe the decision, the greater the degree of capacity that has to be assumed before the person can actually make that decision. And it's that foundation that we build upon and is central to how it operates in practice. So, whilst I do understand the honourable member's position, and I do have a certain degree of sympathy with those who support these amendments, I would invite perhaps a period of reflection in the time we have left in this particular debate to think whether this actually achieves its stated aim. Does it make this bill better, or does it make this bill more complicated and convoluted? I say it makes it more convoluted. I say that despite the best intentions of it, it is not a group of amendments that should be supported. I'm grateful.
Daniel Francis.
Thank you, Chair. Before I start, I do want to say what I'm about to say, I think that my honourable friend from Henderson Stockbridge knows I'm an ally on these issues, but I will humbly disagree on some matters on this perspective. You know, I'm not a lawyer, I'm not a doctor, but like many people here, I do speak from lived experience, and I do speak to someone who is the parent of a learning disabled child. So I do see, on a day-to-day basis, those kinds of decisions that you have to make, and those kind of arguments and conversations that you have to have with people who presume your child has more capacity than she has, or less capacity than she has. And believe me, that is a constant daily battle that my wife and I have. You know, my daughter has 12 words, a severe sight impairment, which makes it very difficult for her to make some of her decisions, as well as other complexities, you know, predominantly her cerebral palsy, which caused her brain injury at birth. And therefore, in my own way, not being a lawyer, but not being a doctor, I have become, I would think, a bit of an expert about some of these capacity issues that you make on a day-by-day basis. You know, this morning, as I do most mornings, I read to her 3 choices for her breakfast. She then gives a little bit of time to think about that. I then repeat that, and we get yes or no for those 3 choices, and that's the choice that she makes. Now, if I put those 3 options in front of her, in fact, because of her severe sight impairment, unless I lifted them to here, she wouldn't see them. If they were down there, then she wouldn't see them, be able to make that choice. But she would also be able to make that choice through pointing if it was within that range. But I have doctors call my wife and I all the time, asking to have a conversation, despite having read the notes, with an 11-year-old with 12 words with a severe sight impairment. And therefore, I do query, and I will refer to some of your arguments in a moment, how well acknowledged some aspects of the Mental Capacity Act are currently being carried out. And equally, I have people that believe at times she has a greater level of capacity than she does. I accept, and I've had this conversation with the member in charge on a number of occasions, that this legislation would not be eligible to my daughter. But we did hear in the evidence from NCAT that the vast majority of people with learning disabilities in this country are not in that position. They are making day-to-day lives. They are living in supported accommodation. They are making the kind of decisions we've discussed in this debate, buying a coffee, going to the bank, etc. And I know from my 20 years as a counsellor, and in the last 11 years since our children were born, I've become so involved with a number of other disability charities, those decisions that people make when their child is at that transition age, trying to understand the complexity of having to make that power of attorney or those decision-making issues for their child. I spend a lot of time actually with parents who don't put those measures in place because they don't understand the complexity at that age, and therefore could have a young adult in this position where that young adult is relying on doctors who do not know them. And at the moment, because the amendment hasn't been tabled and I haven't seen the amendment, so I still talk about the judge at this stage, a judge who has to take that level of decision making about that capacity.
Would the Honourable Member give way?
Kim Leadbeater.
I don't particularly have a question to ask the member, but I just want to pay testimony to him for the way that he has engaged so positively with the process of going through this bill, and to pay tribute to him for the very personal experience that he shared with the Bill Committee. And I want to reassure him that I will do everything I can to work with him, as I have done so far through this process, because his fears are real, and I hear those fears. And I think we've got a job to do through the bill to solve problems that exist for people who are dying, but what we don't want to do is create other problems, and I would be very happy to continue to work with him to make sure we address as much of that as we can through this bill committee.
Daniel Francis.
Thank the member in charge for her comments. You know, that's the conversation we had when she invited me to join this committee, and we'll continue to have those conversations, I'm sure, as those amendments come forward. But my concern is about some aspects of the Mental Capacity Act, and that it wasn't written for these scenarios. You know, the member for Richmond Park has talked about those particularly statutory principles within the Mental Capacity Act. But I'm not an expert, and I've got colleagues here, particularly the member behind me, who is more of an expert. on some of these issues. But when you look at the code of practice, for instance, you know, there is, within the code of practice, there is no actual obligation to consult others, carers involved in people's life within the Mental Capacity Act. What it actually says is, if it's practical and appropriate to do so, consult other people for their views about the person's best interests. So in the kind of scenarios that I'm discussing, the way the Mental Capacity Act and its code of practice are currently worded, there is no obligation for those issues. And the other thing, before I took the intervention that I was going to turn to locally again, is again, if you go to my local MenCap branch, and the considerable hard work Bexley MenCap do, you have people there who, many of those parents are in their 70s, in their 80s, have cared for their child all their life. And I'm not being rude, their child, who is in their 40s, their 50s, does feel a burden to their parents. They do know the obligation their parents have given to caring for them their whole life. And I do just ask members to consider, you know, what the Mental Capacity Act says, those adults are at a level of capacity, as we've heard, to make those decisions, but have been supported in most decisions all their life and do not need to be supported.
Well, the other members could wait. I know
Absolutely.
you to wind up. And look, I know we've spoken a lot today about further safeguards and provisions beyond the Mental Capacity Act when it comes to additional clauses. I note the honourable member has put in Amendment 339 specifically around if a person is autistic or has a learning difficulty, they must be given accessible information sufficient time to consider it. Additionally, there must be a supporter and an advocate with them. Would that therefore, if that amendment was passed, would that satisfy some of your concerns around the Mental Capacity Act?
Thank you, Chair. Well, I think that amendment's going to need some more further rewording from what I'm hearing. But it would address some of those concerns, and again, working with MenCap, there will be further amendments coming to later clauses of the bill. And I understand one of our colleagues is also taking further amendments on that, which I welcome. But I still do say, in terms of interpretation, and there are interpretations there which I've addressed particularly about involvement of carers and loved ones within the current code of practice, I still would have those concerns. And the concerns that brought me to the place that I came to at second reading, because I didn't seek to be this person standing here. You know, if you'd asked me a year ago, not only did I not believe I'd be a member of Parliament, I never believed I would be on this side of the argument. You know, it is this particular point that has driven me to this place. I will just talk a little bit about evidence. So if you look at the Law Society's evidence, and the Law Society have got a neutral position on this, but they do say that before this provision becomes law, a comprehensive consultation should be undertaken to allow relevant experts to share views on the appropriate definition of capacity for the purposes of this bill. So that's the position from the Law Society. Now we've heard what we heard, other members have referred to the oral evidence. But the way, when I've gone back and looked at what Sir Chris Whitty said, he did actually refer to the fact that he believed that it may require some slight adjustment in terms of training. So even he is saying that the current Mental Capacity Act, the definition of it, does not code for this scenario. And if you look at the other evidence, and I'm a strong believer, if we're going to have this debate about having heard the oral evidence, let's hear the oral evidence on this matter. Dr. Rachel Clark, the elephant in the room with all this is the capacity assessments. I would suggest that anybody who pretends that those assessments are easy and routinely done well in the NHS has not got enough experience of observing that happening, what I refer to in my personal experience. I teach capacity assessments to doctors and medical students, and it's often the case that they're very poorly conducted. The doctor often does not understand the criteria for assessing capacity. Dr. Sarah Cox, I and my colleagues are concerned about the safeguards in the bill, and it's not just the capacity assessment. Professor House, when referring to the presence of diagnosable mental disorder, the top of this importance is depression, which is well known, particularly in the elderly, not to be that easy. Baroness Faulkner, for example, you've been discussing capacity, and capacity is a very serious consideration in our concern. Dr. Hussain, I really like what you said yesterday. We need gold standard training. The thought about what happens with capacity made me think straight away about cases in the last few months where we as a palliative care team thought that someone had capacity and the other team did not.
Would the Honourable Member give way? On that point, he's citing some really interesting observations from the oral evidence there, and I welcome him for doing that. I hope I can draw his attention to Amendments 186 and 198 in my name, which look at the training, and this is something I feel passionately about, that if this bill were to pass, having, as I said during that session, gold standard training is vital, it's crucial, and I will do whatever I can to embed that within the bill, and certainly look at what that would look like, particularly in the instances that we're discussing now.
Daniel Francis.
I thank my honourable friend and I welcome that commitment and look forward to that discussion in due course. But Dr Hussain went on to say, ultimately, I do not think the Mental Capacity Act and safeguards in training are fit for purpose. Professor Owen said to us, there conveys questionable confidence in the consent processes of which mental capacity is part in relation to the decision to end one's life. It's significant evidence about the confidence that is out there among experienced practitioners. And Dr Price said, I'll refer back to Professor Garbo's oral submission, thinking about the purpose that the Mental Capacity Act was drawn up for, and the fact that decisions about the ending of life were not one of those originally designed functions of it. We need to think carefully about how that would then translate into a decision that was specifically about the capacity to end one's life.
Will you give way?
Absolutely.
I'm very grateful, Chairman. I know the point about training. Of course, we'd all very much welcome the strongest possible training to be provided, but as he implies there, does he agree that nobody has yet used the Mental Capacity Act to assess somebody for an assisted death? It would be completely uncharted territory for the whole system, including anybody providing training. How does he imagine that training might be designed to allow for the Mental Capacity Act to be applied in this case when it would be completely novel?
Daniel Francis.
Well, again, as I say, I'm not an expert on this matter from a legal or medical background, but they are the concerns that have driven me to the place that I'm in. And again, I would refer you to the last piece of evidence I will cite from Dan Scorer from NCAT. And again, as my honourable friend knows, I was adamant that they would give evidence to us. And he said, building on the previous question about the adequacy of the Mental Capacity Act, there's a question about the adequacy of training, awareness and compliance with that now. And he clearly cited what many people know about what's occurred during COVID with do not resuscitate orders, with decisions being made on people's behalves. So that's what's driven me to this place, Chair. That's why I will support the amendments. Clearly I've got further amendments in my name about this issue later on down the line. But I think we do need to seriously go away and hear what my honourable friend said about training and completely understand some of those decisions and some of those scenarios, because I absolutely understand that somebody at the end of their life should have the autonomy and choice to make decisions. But if that comes at the price of one person where a borderline capacity decision is made on their behalf, then it is one death too many.
Danny Kruger.
Thank you very much indeed, Chair. And it's a great pleasure to follow the honourable gentleman, and I pay tribute to the very, very powerful speech that he gave. And I do wish we had more people on our side of this debate on the committee who had medical backgrounds, but I'm very glad that we have someone who has such personal direct experience of supporting people with learning disabilities, and I'm grateful to him for everything he said, and I entirely agree with it. I want to speak in support of the Honourable Lady's amendment to replace the Use of the Mental Capacity Act with a new ability test. This does go to the heart of the bill. It's absolutely crucial, and Clause 3, which her new clause would replace, is in a sense the essence of the bill. It's the shortest clause, but it's perhaps the most important one because it determines the means by which somebody will be assessed to be capable of making this decision. It's a very, very important protection. And at its simplest, and it is a very confusing and complicated area, I'm going to confuse myself, no doubt, of course, in my speech. But I do have this very simple observation to make, and the Honourable Lady made it very well. We're dealing with the issue of impaired judgment. And currently, under the Mental Capacity Act, it will be possible, by the terms of this bill, for somebody whose judgment is impaired by virtue of a mental disability or mental illness to successfully apply for an assisted death. I don't think that's what the public want. I don't think it's what the House of Commons voted for. I think it's a misunderstanding of the principle of the bill that did win support at second reading. The simple fact is that your judgment can be impaired under the Mental Capacity Act, but you could still have capacity. And we've heard repeatedly points made about how the Mental Capacity Act applies in the normal conduct of life for disabled people, for people with mental disabilities. And for instance, you can be anorexic, you can be suicidal, you can be depressed, and of course you can still consent to all sorts of decisions that are made that affect your life, including medical treatments. You can have surgery on a broken leg while depressed, and you can consent to that, no difficulty whatsoever. Of course that's appropriate, and that's the right basis on which we currently judge capacity. And the amendment that the Honourable Lady is introducing will build on the terms of the Mental Capacity Act. It adds to the principles of autonomy and of people being able to understand, use and weigh the relevant information. But as I said in an earlier intervention, the key point is that using this new test of ability will ensure that the person is fully able to do those things, fully able to understand, use and weigh the relevant information. So in the case of impaired ability, they would not be considered to pass the test. And I know, Madam Chair, we hear a lot that this is the toughest bill in the world with the highest safeguards. It's worth pointing out that in Oregon, which this bill is largely inspired by, there is an impaired judgment test. There is the capacity test, similar to that in the Mental Capacity Act, but you are also required to demonstrate that there is no impaired judgment. And that's exactly what the Honourable Lady is seeking to do, building on the terms of the Mental Capacity Act, those key principles about understanding information, but ensuring that that is a full understanding with no impairment. So it strengthens the bill without complicating it. In fact, it significantly simplifies it. Because at the moment we have the problem, and this is the substantial issue with the application of the Mental Capacity Act, that we have a huge complication involved. When we go into the forest of the MCA to try and apply it in these terms, to use it to navigate our way through the MCA in pursuit of an assisted dying application, we have a whole series of complications. And it's for that reason, I cite some of the evidence that we got. The Royal College of Psychiatrists, who we did hear from, stated in its written evidence, it is the Royal College's view that the MCA is not sufficient for the purposes of this bill. I also cite the evidence we had from the King's College London Complex Life and Death Decisions Group, which is a group of world-leading professionals working at the end of life. They describe it as the use of the MCA for assisted suicide would be an entirely novel test. And I note the Honourable Lady for Penistone and Stockbridge made the point that the ability test would be, and I think my friend from Solihull made the same point, it would be a novel term. The term of ability is not currently set out, it's not recognised in law in the same way that capacity is, and I acknowledge that. But as I said, actually, ability is very clearly defined in the new clause which the Honourable Lady is proposing. And of course it's going to be novel. We're talking about something that is entirely novel. The assisted suicide is a new measure that's being introduced. So of course we have to have a new measure by which we define who should be appropriate.
I'm reading the text of New Clause 1, and it's remarkably similar to the text of the Mental Health Act, Section 3, A and B, which I'll read out. For the purpose of Section 2, a person is unable to make a decision for himself if he's unable, A, to understand the information relevant to the decision, B, to retain that information, C, to use or weigh that information as part of the process of making the decision. This is not a novel concept, because that's virtually exactly what the wording is in New Clause 1. So I don't see why we need to have this new clause or new definition, because it's already there in the Mental Capacity Act.
Danny Cruz.
Well, gratefully, he helps me explain my point more clearly, which is the new clause the Honourable Lady is proposing builds on the terms of the Mental Capacity Act. It recognises the value of the terms that have been well established in case law through the MCA about the ability to understand, use and weigh the relevant information. The key difference is this word fully. So the case law around the MCA allows for somebody to be deemed capacitous even though their judgment might be impaired. What is being proposed here is that exclusion would, or that lacuna would be closed. So it would not be possible to get an assisted death if your judgment is impaired. And that is the key difference. And it is also important, going on, to exclude the MCA because of the thicket of complications, and we've heard about the importance of simplification, the thicket of complications that it would entail. A much simpler and better way to do this entirely novel thing that we're proposing, which is to authorise assisted suicide by the state, is to have a new definition. She doesn't like my terminology.
I do
Kim Leadbeater.
I do struggle with that terminology. This is not assisted suicide by the state. It is, the state is not involved. It is the person making the decision, an autonomous decision based on their choice at the end of life. And I will say on the record now that the term suicide is not an accurate term for the cases that we're talking about. The people that we're dealing with are not suicidal. They very much want to live. They don't want to die, but they are dying. And I think it's important that we have that on the record.
I am grateful. I think it's totally valid for us to have this argument periodically about the terminology. I will repeat the point that I've made before, which is that actually we are amending the Suicide Act, or rather we're disapplying the Suicide Act in the case of the process that's set out in her bill. So there's no getting away from the fact that we are talking about assisting suicide. And I'm afraid I will continue to use the term, and I hope she'll forgive me for that. So I'm trying to argue, Madam Chair, that the MCA is a complicating factor in the process that is being proposed for the bill. It makes things much more difficult and complicated. So, and I want to quickly refer, and the point's been made. You know, I honour the Honourable Lady from Richmond Park put it very well. I think a lot of the case for the MCA, a lot of weight is being put on the evidence from Sir Chris Whitty that he gave us, suggesting that the MCA works very, very well. I do want to point out there was a significant mistake that Sir Chris made in his evidence to us when he said that the more serious the decision, the greater the level of capacity that someone needs to have. There's no such requirement in the Mental Capacity Act. Of course, he'd hope that doctors would take a serious decision more seriously than a trivial one, but there is no such requirement. And I do want to quote from Alex Rupp-Keane, KC, who wrote in, I think, to the Honourable Lady after his evidence session, and he said, with the greatest respect to Chris Whitty, the fact that he got that wrong does not inspire confidence in his comments that the Mental Capacity Act is well understood by doctors throughout the country. And I very much echo that. We've had so much evidence of how the Mental Capacity Act does not work well in practice. For him to have made that Panglossian observation that every doctor interprets it in exactly the same way and it works perfectly everywhere, I think was regrettable. Now, a few more quick points, Madam Chair. The Mental Capacity Act doesn't detect coercion. We'll discuss coercion more in subsequent debates, but this certainly is not the safeguard against it. I also want to quickly reference a point made, I think, by Professor House to us about Down syndrome and his comment about diagnostic overshadowing. I think it's a very important concept, which is that it's, I'm afraid to say, very frequently the case with people with severe disabilities, that capacity or indeed incapacity is not correctly observed because of the way that the medical professional will not see beyond the more presenting of their conditions. And so observing capacity in someone who does have disabilities is often mistaken. It's harder than it is for other people. And just on the subject of Down syndrome, I do refer the committee, if they haven't read it, to the very, very powerful piece by Dominic Lawson in the newspapers this weekend about his daughter who has Down syndrome and the struggles that she and her family, his family, have with accessing equitable treatment and fairness in the system. There are, as the Honourable Gentleman said, there are profound problems in the way we currently deal with particularly with young people with learning disabilities. Also quickly observe the point made by witnesses about what's called the fluctuating capacity that is inherent in certain conditions, particularly dementia. And the point about a decision for assisted death, once you made it, you can't unmake it. Another, by the way, a key distinction between requesting assisted death and declining treatment. You can also always go back on your decision to decline treatment. You can't go back on your decision to have an assisted death. But capacity fluctuates, particularly with dementia. Happy to.
I thank the Honourable Member. Can I clarify that what he's proposing to introduce a separate test for people accessing assisted dying would mean that an individual, say on a respirator at the end of their life, if they said, please turn this respirator off, I want to die, that from what he's proposing, he thinks that that's appropriate to be assessed. The capacity for that person to do that is to be assessed under the Mental Capacity Act. But somehow that person should have a different legal test if they say, I want to take a drug to end my life, knowing fine well they have exactly the same results.
Simple answer is yes, I do. I think it is a qualitatively different decision. And in fact, this whole bill entails qualitative differences between those decisions. I'm going to come on more to that point in a moment, but to answer this point, yes, I do. Now, an important point made by Professor Owen to us around capacity. I'll quickly quote a few lines from him. He said, you might be talking about a kind of cognitive impairment that has not reached the threshold for a diagnosis of dementia. And he talked about mood problems, anxiety problems that is subclinical. Or you might be talking about a level of intelligence that is not clinically a learning disability. And he talks about pressure within a family, let us say, which is not often malign in its intentions, but it exists. And he talks about where there is an impairment and also interpersonal pressure. So, although we're not talking at this point explicitly about coercion and family pressure, nevertheless, the issues around capacity and coercion are very, very intertwined. And it's often very, very difficult for doctors to determine what is really going on. So again, the challenges around capacity are intense. Now, the point's been made by honourable members in the debate that there is currently an opportunity for one of the doctors, it's the second doctor in the process according to the bill, section 9, subsection 3b, if they're in doubt about capacity, they may refer to a psychiatrist or to a registered medical practitioner who has experience of the assessment of capacity. So not a psychiatrist, actually, just someone who's got experience, whatever that means, of the assessment of capacity. It's not totally obvious what that means. I think there is an amendment has been tabled by the honourable member for Bath overnight, which suggests that both the first doctor and the second doctor, and indeed the court, if we are allowed to have a court, they must be satisfied, not just may, but if yes, they must be satisfied, so they must refer to a psychiatrist. Not just if they're concerned about capacity, by the way, but if they fear that the court, or whoever it is, must conclude that there is no impairment of judgment arising from a mental disorder or other conditions. So I very much welcome the amendment tabled by the honourable member for Bath, and I hope that we'll pass that in due course. Happy to.
Kim Leadbeater. Just on that point, in terms of clause 9, subsection 3b, I think it was mentioned earlier on by a colleague, an amendment has been put forward by the honourable member for St Albans. That's an amendment I would look to support, and I hope the Bill Committee will support it, which would indeed turn the may to a must in terms of there has to be a referral to a psychiatrist if there is any doubt from either of those doctors.
Danny Crew. Okay, well, for the first time so far in the course of this debate, Chairman, we have a strengthening of the bill from the honourable member. So that is great news. We can chalk that up as a victory and good stead breaking out. So I'm grateful for that. Let's see what more we can achieve. The point I want to make, Madam Chair, and I'm coming to an end, is that we are in the foothills of understanding the effects of depression, cognitive impairment and social pressure on the decision to end life. And this is a point made strongly by a series of witnesses to us, written and oral, that we are still very much in the early stages of understanding how capacity interacts with mental illness, with disability, and indeed with coercion. And we are proposing that into the midst of vagueness, we are going to insert this single, clunking, clumsy question. Is there evidence of incapacity? And I want to strongly suggest that the use of the Mental Capacity Act, well, the abuse of the Mental Capacity Act that we are seeing here is not a way of simplifying the process of ensuring that there are a small number of strong safeguards. It's a great complication of the process. It introduces more complexity, as we see, because there's all sorts of additional things that are being added that clinicians should consider, which is in direct contradiction to the principle of the Mental Capacity Act, which simply asks this question: is there capacity? So, the Mental Capacity Act, and the point's been made, there's more to it than simply this question of capacity. There are concepts of best interests and of supporting decision-making. I mean, as the member for Penistone and Stockbridge suggested, it's a cumulative process. The Mental Capacity Act entails not just this question of capacity, but also we're supposed to consider best interests and whether we are supporting the decision-making of the individual. I'm not sure how those terms apply in a situation of assisted dying. It's just not similar. It's not comparable to the sorts of decisions that the MCA is intended to apply. Happy to.
Lewis,
I thank him for giving way. I think this touches on some of the evidence given by Mr Rookeen in his, particularly around the best interest decision. I mean, my reading of the draft legislation is very, very clear that there is no possibility for someone to make a decision on behalf of in best interest for anyone else. But I think, as the member for Solihull has referenced earlier, there are a number of exclusions in the existing Mental Capacity Act. For example, someone is not able to make a best interest decision on someone getting married or on someone adopting. So does the member agree that in order to potentially absolutely guarantee without any doubt on the best interest point, there could be an insertion of an amendment to clarify that nothing in the MCA would allow a best interest decision under this Act?
Well, I'm grateful to him, and I think that is absolutely right. I don't think best interest can apply in this case. But that's why this act is, the Mental Capacity Act is being abused, because as the Honourable Lady said, it's supposed to be cumulative. We're supposed to consider all of these aspects of the Mental Capacity Act. Best interest should be part of the consideration, but indeed, how on earth do you make a best interest decision about somebody deciding to commit suicide? So the Honourable Gentleman is absolutely right. Best interest is excluded in this act. So it's not the Mental Capacity Act is not being used except for this most basic, low-level bar to cross, which is the capacity decision.
So thank you. Just for clarity, and I agree with the Honourable Member for Sunderland Central that this would strengthen the bill, but those exceptions only apply where the right and proper Mental Capacity Act process has been gone through and the person doing that assessment has arrived at the point that that person doesn't have capacity. And it's only in that very narrow set of circumstances where they have determined that the person before them does not have capacity to make the decision at hand, that then they go to a second look at whether making such a decision would be in the individual's best interest. So those exclusions, the specific exclusions that are listed in the MCA, only apply in that stage. And what the Honourable Member for Sunderland Central is suggesting is that we make an amendment which would add to that list of very specific exclusions. So it would further strengthen the two stages. Number one, that you would go through the full Mental Capacity Act tests and you would determine that that person doesn't have capacity. But it would give us belt and braces in those circumstances where the person does not have capacity, which under the Act currently, therefore they would fall out of scope, they would not be able to seek assistance if it had been determined that that person hadn't got capacity. However, it adds belt and braces to make sure that there is no circumstance in which it could be determined by a medical practitioner or other that it was in their best interest to follow this course of action. So the law as it currently stands, as the bill is currently drafted, means that those people who haven't got capacity as a result of the Mental Capacity Act would not be able to have access to the provisions in the bill. We are saying, or my honourable member makes the point, to suggest that we add and augment that even further so that there can be no doubt that where it has been determined that the person does not have capacity following the Mental Capacity Act, that we should also add a very clear exception.
Order, it being 11:25, the committee is now adjourned until 2 p.m. Order.